All right, we've got this breaking news just coming into our newsroom right now.
Well, later today, a landmark civil rights case is set to be argued before the Supreme Court.
Major Supreme Court ruling
Over the future of gun control.
The U.S. Supreme Court has just issued a major ruling involving the Second Amendment.
The Supreme Court has issued a ruling.
The Supreme Court will be taking up a gun rights case.
This ruling strikes down a New York law that put restrictions on who could get a license to carry a gun.
The court will consider whether people who use marijuana can legally own guns.
The Supreme Court agreed to hear a case on whether federal law can bar drug users from owning guns.
It's a case that legal experts will be watching closely when it likely heads before the justices.
The Supreme Court just agreed to hear a case that could redefine who counts as the people, protected by the Second Amendment. This isn't about convicted felons or violent criminals. This is about whether the government can permanently strip constitutional rights from tens of millions of Americans based on personal choices that have nothing to do with violence or danger. 8 million Americans are currently banned from owning firearms under federal law. That number grows by hundreds of thousands every year as Congress adds new prohibited categories. But the case the Supreme Court just granted review could affect an additional 31 million people overnight, and most of them have no idea they're even at risk. The Second Amendment states clearly, the right of the people to keep and bear arms shall not be infringed. Yet federal law has created over 20 different categories of people who are permanently or temporarily prohibited from gun ownership. Congress keeps expanding these categories annually, and the Supreme Court has never clearly defined who qualifies as the people deserving constitutional protection. The case granted review today challenges one of the most widely applied prohibition categories in federal law. It affects millions of Americans who may not even realize they've crossed a legal line that could cost them 10 years in federal prison. Federal Statute 18 U.S.C. 922 G3 makes it a felony for anyone who is an unlawful user of or addicted to any controlled substance to possess a firearm. This law has resulted in over 7,500 federal prosecutions in just the last 3 years alone. The penalties are severe, up to 10 years in federal prison for possession of even a single firearm. Here's what makes this particularly dangerous. The term unlawful user has no clear legal definition in the statute. Federal prosecutors exercise enormous discretion in deciding who qualifies. They've charged people who used marijuana weeks or even months before touching a gun. In some cases, prosecutors have applied this statute to people whose only evidence of drug use was a single positive drug test or admission during a police interview. This creates an absurd constitutional nightmare in states where marijuana is legal under state law. Residents engaging in perfectly legal activity under state regulations still face federal prosecution because marijuana remains illegal under federal law. State legal conduct triggers loss of federal constitutional rights. You can legally purchase cannabis from a licensed dispensary on Tuesday, then face federal felony charges for owning a gun on Friday, even though you're completely sober when handling the firearm. The Fifth Circuit Court of Appeals ruled in this specific case that the federal government cannot ban someone from possessing firearms unless they were actually intoxicated at the moment of possession. This seems logical on the surface. If being drunk doesn't permanently ban you from gun ownership, why should past marijuana use? But this reasoning exposes a massive gap in how courts interpret who the people are under the Second Amendment. If the government can strip constitutional rights based on disapproved behavior even when you're not engaged in that behavior at the time, what stops them from expanding prohibited categories indefinitely? Consider the precedent this sets. If past drug use justifies permanent firearms prohibition, why not past alcohol abuse? Why not prescription medications? Why not any other legal activity the government decides makes someone irresponsible? The logical endpoint is that gun ownership transforms from a constitutional right into a government-granted privilege that can be revoked based on subjective determinations of worthiness.
This case could reshape how far states can restrict your right to carry.
That's unconstitutional. That puts a limit on the right to have a gun.
Everybody has a right if they're a responsible adult.
The right to keep and bear arms shall not be infringed.
It conflicts with the Second Amendment's right to bear arms.
Saying setting a higher threshold in an emergency could mean life or death.
That law cannot stand.
My response to that is that's the same claptrap that they have been using for 20 years.
The Supreme Court's landmark 2022 Bruen decision established that gun regulations must be consistent with historical tradition. Yet the government argues that 18th and 19th century laws disarming dangerous people justify modern prohibitions on anyone who uses substances that weren't even illegal during the founding era. Historical records tell a different story. The founders never created broad categorical bans on gun ownership. Instead, they focused on disarming disarming people during actual dangerous conduct, not based on status or past behavior. Someone who got drunk on Saturday didn't lose the right to own firearms on Monday. The concern was always immediate danger, not disapproved lifestyle choices. This case will force the Supreme Court to decide a fundamental question. Does the people mean all citizens unless individually proven dangerous, or can the government carve out entire classes of Americans from constitutional protection based on conduct it disapproves of? The answer will determine whether your Second Amendment rights are truly constitutional protections or merely privileges that can be stripped away whenever government decides you're not responsible enough. But there's something crucial about how this case reached the Supreme Court that reveals the government's strategic thinking. The Department of Justice had dozens of similar cases involving drug users and gun possession working through federal courts, yet they specifically chose this case to bring before the Supreme Court. The reason reveals their entire legal strategy. The defendant in this case has multiple factors making him extremely unsympathetic to judicial review. He holds dual citizenship with a country that has complicated relations with the United States. He was placed on a federal watch list. Evidence exists of communications with questionable foreign contacts. He admitted to frequent marijuana use while also possessing other controlled substances. By selecting a defendant with this profile, the government is betting that Supreme Court justices will be reluctant to rule broadly in favor of Second Amendment rights when it would benefit someone who appears to pose potential national security concerns. This is textbook legal strategy. Choose the worst possible defendant to test constitutional limits, knowing that courts are more likely to restrict rights when the immediate beneficiary is unsympathetic. This is the same playbook federal prosecutors have used in previous landmark cases. They deliberately choose unfavorable defendants, knowing that bad facts make bad law. Statistics bear this out. When the Supreme Court takes cases involving rights of unpopular defendants, they rule in favor of the government 68% of the time compared to only 43% when defendants are more sympathetic. The shadow of last term's Rahimi decision looms large over this case. In United States versus Rahimi, the Supreme Court addressed whether people subject to domestic violence, restraining orders could be prohibited from possessing firearms. The court upheld that restriction in an 8-1 decision that sent shockwaves through Second Amendment advocacy circles. The majority opinion included language about courts taking a more nuanced approach to Second Amendment cases and considering how societal problems have evolved since the founding era. This seemingly innocuous language immediately gave lower courts permission to water down strict constitutional scrutiny. In the 6 months since Rahimi was decided, federal district and circuit courts have cited that nuanced approach language in at least 34 published decisions to uphold gun restrictions that previously would have failed constitutional review under the Bruen standard. Courts are now using Rahimi to justify assault weapon bans, high-capacity magazine prohibitions, may issue concealed carry schemes, and enhance background check requirements, all by arguing these restrictions are nuanced responses to modern problems. The government's petition in this new case cites Rahimi 18 times and explicitly asks the Supreme Court to further develop the framework established there, which is code for give us more tools to restrict gun rights. They're not just seeking to win this individual case, they're seeking to establish broader principles that will allow future restrictions on entire categories of gun owners. Here's the fundamental difference that makes this case potentially more dangerous than Rahimi. Domestic violence restraining orders require individualized judicial findings of dangerousness based on specific threatening conduct. A judge must review evidence and make a determination that this particular person poses a credible threat. Drug use prohibitions, by contrast, apply categorically to millions of Americans based solely on their personal consumption choices without any individualized determination of threat. No judge reviews whether this specific person poses danger. No hearing examines whether their drug use actually impairs judgment or increases violence risk. The prohibition is automatic and categorical. Research from the Rand Corporation found that people who use marijuana are statistically no more likely to commit violent crimes than people who drink alcohol. Yet alcohol consumers face no federal firearms prohibition, while cannabis users lose their Second Amendment rights, often permanently, until they can prove sobriety through expensive and invasive monitoring. The disparity reveals the arbitrary nature of these prohibitions. If the concern is intoxication-related accidents or impaired judgment, why does the law treat chemically similar substances so differently? The answer has nothing to do with public safety and everything to do with which behaviors government has chosen to criminalize. The Supreme Court has never directly addressed whether the Second Amendment protects only law-abiding citizens or all citizens unless individually proven dangerous. This case will force them to answer that exact question in a way that affects not just drug drug users, but potentially any future category of people the government wants to disarm. If the court rules that the people can be narrowly defined by Congress to exclude anyone engaged in behavior the government disapproves of, it would fundamentally transform the Second Amendment from an individual right into a government-granted privilege that can be revoked based on subjective determinations of responsibility. Consider the precedent this establishes. Today it's drug users. Tomorrow it could be people with certain mental health diagnoses. Next week it might be people who engage in risky hobbies like skydiving or motorcycle riding. Next month it could be people whose social media posts express concerning political views. Once you accept the principle that government can categorically disarm entire groups based on disapproved conduct rather than individualized danger assessments, there's no logical stopping point. The implications extend far beyond firearms. If constitutional rights can be stripped categorically from people engaged in legal conduct the government simply doesn't like, that principle applies to all constitutional protections. Your First Amendment rights could be limited based on past association with controversial groups. Your Fourth Amendment protections could be reduced based on living in a high crime area. Your voting rights could be restricted based on failure to meet government-defined responsibility standards. The Supreme Court's decision in this case won't just determine one man's fate. It will define whether your Second Amendment rights are truly constitutional protections or merely government privileges that can be stripped away whenever they decide you're not responsible enough. It will establish whether the people means what it says or whether it means people the government approves of. This is arguably the most important gun rights case of the decade, and most Americans have no idea it's even happening. The mainstream media won't cover what's really at stake here because the case involves drugs and an unsympathetic defendant. But strip away the specific facts, and you're left with a fundamental question about the nature of constitutional rights in America. Are your rights truly yours, protected by the Constitution against government overreach? Or are they conditional privileges that government can revoke whenever it decides you've engaged in behavior it disapproves of, even when that behavior is legal, non-violent, and poses no threat to others? The Supreme Court will answer that question in the coming months, and their answer will determine the future of constitutional protections for generations. That's it for today, folks. See you in the next video.